Hello, welcome to a brief web chat on insolvency, hopefully quite short. This is on disposals in an administration, the new regulations that apply under paragraph 60A of Schedule B1 to the Insolvency Act 1986, and the administration restrictions on disposal, etc., to connected persons regulations 2021. And don't worry if you haven't had time to write that down, because there are quite full slides in the caption there somewhere here and through. And actually, it can be helpful to have a look at this, looking at the slides at the same time as the talk, but up to you in that's going through. So this time we're going to look at who is a connected person for the purposes of these new regulations. And there's also going to be a second slide, because there's so much in this, for if there's a connected disposal, who can be an evaluator, who can be an independent evaluator for these purposes. These are just discussions. If you're a solicitor, that's fine, but you should instruct us direct. If you're not a solicitor, then go and instruct a solicitor, try and find what's going on. This is all quite new legislation, last April, only recently enacted, and much is going to depend on the facts. So now over to Tom, who's going to talk about a summary of the regulations.
Thank you, David. Hello, everyone. Yes, so 30th of April last year, new regulations came into force, and they apply to all administrations commencing on or after that date. And the way I think about their effect is that they impose a requirement on administrators. And the requirement on the administrators is, well, engaged, it bites on those who seek to dispose, hire out, or sell all or a substantial part of the company's property to one or more connected persons. So if the administrators are seeking to sell that amount, so all or a substantial part of a company's property to one or more connected persons, then these regulations are engaged. And they apply to disposals in the first 8 weeks of the administration. There are 2 SIPs that are already in place, already in force. They continue to apply. And they may apply even if these regulations don't. So SIP 16 applies to pre-pack sales in administrations, and SIP 13 applies to disposals of assets to connected parties in an insolvency process. They may apply even if the sale is after the 8 weeks, and even if it's not a pre-pack sale. You may find you need to look at those SIPs. But for these regulations, we're focusing on what we're calling disposals. They're disposals to connected persons, and they're within the first 8 weeks of the administration. The new requirement on the administrator before entering into such a disposal is either to obtain creditor approval or to obtain a report from an evaluator. The creditor approval route, you can either put it in the statement of proposals under para 49, or you can get specific creditor approval to it. That's under Reg 4. So that's route 1. Not sure how likely that's going to be in practice, given the time it might take to do all that. So the second route is to obtain a report from an evaluator, a bit like using the old pre-pack pool. And the evaluator needs to be an independent person with relevant knowledge and experience and insurance in place. And the evaluator then gives an opinion on whether the consideration and grounds for the disposal are reasonable in the circumstances. And as David said, there'll be a separate talk where we're looking at the evaluators and how to identify whether they are independent or not, or excluded from consideration as a possible evaluator. And that's going to involve some questions of connection association as well. But for today, we're just looking at the issues of who is connected for the purposes of the test of, is this a disposal to a connected person? There are all sorts of other questions that arise on these regs. For example, what's the consequence of breaching them? I've put a note together, which is on the Wilberforce Chambers website, trying to look at some of those. But for today, we're just going to focus on identifying the connected persons and therefore knowing whether the regs are engaged at all. So David, how do we identify a connected person under these regs?
Right. Well, a connected person is different from someone being connected, unhelpfully, defined elsewhere in the Insolvency Act, but is used in this definition. So para 60A sub 3, a connected person in relation to a company. So that's the insolvent company, which is in administration. It's got the administrators appointed, is defined as anyone who's either a relevant person or a company that is connected with the insolvent company. So you've got 2 limbs, relevant person or connected with. A relevant person is someone who is a director or other officer or a shadow director of the company. So if you sell or dispose or lease something to a director or other officer, shadow director, or a non-employee associate of a director or other officer or shadow director. So that's a sort of second limb, or a non-employee associate of the company. Now, that's a very similar test, in fact, broadly, to what's in Section 249 of the Insolvency Act, the connected person test, not for this purpose, but for general purposes like transactions and undervalue, except it excludes from the test in what's in 249, which is someone who's associated by reason just of being an employee. You can be associated if you're not something else. If you're a person who's also a director, you'll still be associated. But if your only association is being an employee, you're not within that test. Now, the terms like officer, shadow director, and director, it's not massively clear, but they're probably going to have the same meaning as in the rest of the Insolvency Act. And officer's probably going to include the insolvency practitioner. There's been a recent case on that, which is in the slides, Northern Derbyshire Magistrates, on a slightly different section in a different act. It's probably going to apply here. So who's an associate? That's going to be the wide meaning that's in Section 435 of the Insolvency Act 1986, which I deal with in my new book, Advert, which goes into it in immense depth about how connected an associate comes through. Who's a company? Well, company probably means any body, corporate, wherever incorporated. There's a definition in para 60A6, which cross-refers to section 435.10, but that's probably an error. It should be to section 435.11, which is actually the subsection that defines the term company. So that's probably a typo that's going to be ignored by a court anyway, treated as the right one. So is or has been, is this you, Tom?
I think we're about to get to me about Bidco.
Okay.
Yeah. So we're talking now about this concept of the purchase of all or a substantial part of the company's property. And I'm going to talk about the purchaser in the usual circumstance of it being a corporate as Bidco. And I'm going to talk about the insolvent entity as Insolvent Co. There are broadly three limbs that apply to make Bidco a connected person of Insolvent Co. David's written a book. None of these are in the other book, which I'm looking up. Fascinating. Nothing to do with insolvency. But I just thought if David's going to waive a book, so am I. There are three limbs. The first is if Bidco is a non-employee associate of Insolvent Co. So that's a straightforward relationship if Bidco is actually an associate of Insolvent Co. Maybe by reason of shareholding, something like that, some control relationship. Second route, Bidco is a non-employee associate of a director or shadow director or officer of Insolvent Co. So the non-employment bit, as David says, is unlike 249, but otherwise it's the normal ways in which one company is an associate of a director or shadow director or officer of another one. And then the third limb that I want to consider is where there is some person, call him or her a link person, who is or has been a non-employee associate of one and is or has been a non-employee associate of the other. So that's why we're talking about a link. So there's someone identified as being associate of the Insolvent Co. and associate of Bidco. Now, limbs 1 and 2 probably raise the usual tricky issues that we're familiar with under section 249. You can be connected if you're Bidco with Insolvent Co. because you share a director. So you identify shared directors at a particular point in time. You could have Bidco as a shadow director of Insolvent Co. Probably not lenders, but other entities which exert sufficient control that you could talk about them as shadow directors. Or Bidco, by means of shareholding and therefore control of voting power, could be an associate under section 435. And those are tricky issues. They're quite long-standing issues. And David's book, which he will probably now waive again, cover those. So that's limb 1 and limb 2. Limb 3, this link person, it looks as if from the wording of the regs, the link person has to be at the present time, at the relevant time of the disposal, either a relevant person of Bidco or Insolvent Co. and can't be formally a relevant person of both. So you can't have a former director of one being a former director of another, and that's your relevant link. It looks as if from the way it's phrased, you need to be looking for someone who is a director of Bidco or is a non-employee associate of Bidco, but it doesn't matter if they've formerly been one of the other. And in the slides, we've got a table where we try and identify this, looking at the present relationships being sufficient, but if you've got on both sides former relationships, that's not going to be sufficient. So have a look at that when you look at the slides. This lim 3, this link person, they can be a relevant link simply by means of satisfying the 435 test of an associate. So that's persons in partnership, trustees, and an awful lot of relatives of the individual. You could find, therefore, that a spouse, former spouse, children, grandchildren, parents, grandparents, so on and so forth, are all sufficient to bring within scope a relevant individual who is director of Bidco, and if his relative then has either a past or current relationship with Insolvent Co, you've got your link person and away you go under lim 3. So it's really quite broad. And for a worked example, I think David's going to take us through one to see how this might play out. David.
We're just going to finish off by how difficult it is to work out if you've got a linked person who's connected with one company or associated with one company and associated with another company through directors. So there's a chart in the slide. So it's the individual, parents, uncles, aunts, nephews, nieces, that sort of thing. Doesn't include cousins, includes spouses, which is not the defined term, but includes civil partners and former civil partners, former spouses, and also reputed spouses. Nobody's quite clear what that means, but does that include people living together, but only if they've been held out as being spouses? So we put.
I did a whole case once on whether someone was a reputed wife.
Mm.
The whole case, full cross-examination on whether someone was a reputed wife.
Holding out. I'm a reputed wife. Yeah. Signs out. So I suppose if a company, show how difficult it is, you've got a director of Bidco and they've got an aunt whose former husband is Mr. X, and Mr. X has got a nephew who's a former director of the Insolvent Co. That means they're associated or connected. So it's a sort of former spouse. You can't write down a list of who's connected or associated, or it's going to be very difficult. I couldn't. I've got too many aunts and uncles, even though they're dead now. It's going to be quite tricky working out who is connected or associated. We put some stuff in the slides on this. And if you come to it at the end of the day, it's just very difficult to know whether or not a Bidco is a connected person. Is that going to mean that in practice people will go down the evaluator route to avoid risk of a potential inadvertent, or even with reasonable care? It's an absolute test. Is that company connected or associated? Which sounds like you should know, but you don't know. So there's no express sanction for a breach. You might say, well, let's wait 8 weeks. Is that really feasible? I don't know. Let's get an evaluator's report. Is that really feasible? It's all very tricky, which clearly you need barristerial advice.
Thank you.
But we'll finish on that note, but we'll look at evaluators next time.